This is Barry Selma speaking for Claim School Incorporated's blog, Selma on Insurance. Today we remember and reiterate the fact that bad faith and the tort of bad faith requires an effective insurance policy, and that there is no contractual rights to benefits. There can be no bad faith. The United States District Court granted the motion of insurer Medical Protective Company, Med Pro, and its motion for summary judgment relating to Plaintiff Michaela Jeffery's declaratory judgment action. Then Med Pro moved that because it does not have a contractual duty to indemnify Dr. Justin Clemens, who had acted improperly in treating Ms. Jeffery for his negligent treatment, then Med Pro claimed it was entitled to summary judgment on Ms. Jeffery's bad faith claim. In Michaela Jeffery v. Medical Protective Company, the United States District Court for the Eastern District of Kentucky on July 25, 2024, ruled on the remaining bad faith claim. The background of the case dealt with the fact that from October of 2013 until February of 2014, Plaintiff Michaela Jeffery suffered dental care from Dr. Justin Clemens, then a medical professional, insured by Defendant Med Pro. During this time, Dr. Clemens negligently installed Ms. Jeffery's dental implants and then abandoned her when she needed additional dental work to correct the implants and repair the extraction sites. In response to Dr. Clemens' negligence, Ms. Jeffery sued him in state court and obtained a default judgment of $283,095. Unable to collect from Dr. Clemens, Ms. Jeffery sued Med Pro to obtain a declaration that the company was required to indemnify Dr. Clemens against Ms. Jeffery's default judgment. Med Pro defended, and eventually the parties filed cross motions for summary judgment on the contractual question, and in June of 2022, the United States District Court found that because Ms. Jeffery had failed to fully satisfy the contract's notice requirement, Med Pro was entitled to summary judgment, and Ms. Jeffery's was not owed declaratory judgment, and MedPay had no contractual duty to indemnify her or to indemnify Dr. Clemens from her judgment. The moving party in a motion for summary judgment has the burden of demonstrating the basis for its motion and identifying those parts of the record that establish the absence of a genuine issue of material fact. Once the movement, that is, the moving party, satisfies its burden, the non-moving party must go beyond the pleadings and come forward with specific facts demonstrating there is a genuine issue in dispute. The USDC concluded that Kentucky law was unequivocally clear that absent a contractual obligation, there simply is no bad faith cause of action, either at common law or by statute. Because Med Pro did not have a contractual obligation to provide coverage, summary judgment was found to be appropriate. Dr. Clemens' liability was established, however, since the court found as a matter of law that Med Pro had no contractual duty to indemnify Dr. Clemens for his treatment of Ms. Jeffery. Med Pro could not be found liable for bad faith. In my opinion, it appears that Dr. Clemens has scampered away from the judgment against him, and Ms. Jeffery's judgment was useless, so she attempted to collect from his insurance company that did not defend him to the allegations of her suit. She failed in her attempt to show Med Pro owed a duty to defend Clemens, so her claim of bad faith also failed. Sometimes, winning a suit, no matter how appropriate, and obtaining a judgment, ends up being no more than giving the plaintiff a useless piece of paper. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and receive notice of every blog posting, usually 5 or 6 a week. And you can also gain access to the more than 4,800 blog postings. You can also subscribe free to this video, either on YouTube or on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. They're all free. And please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.